Yes, Mr. Jones.
Good morning, my lords. Good morning, my ladies. Can I just start by picking up a few points from yesterday?
Yes, please.
And just sweep them out of the way, and then hopefully we'll take some of them off the shopping list. The first one is you asked a question yesterday about the orders from the Malaysia courts and whether or not they declared the share transfers, etc., to be void. As your lordship remember, it was a question you asked my learned friend, Mr. Crowe.
Yeah.
And the answer to that is the first tranche of shares is 1,252,000. That's the one known as case 14-4. The judgment appears at 6803 to 6800. And at
6803 to
20, I'm sorry.
Oh, I don't want to be reading it back.
No, my lord. I'm misreading my own handwriting. 6820.
Thank you.
The relevant bit is at 6815 to 6816, where it is said that the share transfers were effected unlawfully and fraudulently and are therefore null and void and of no effect. That's the first one. The second one is the 4 million shares, which is OS 39. That judgment is at 7090 to 7144. And you can see at paragraph 52, which is on 7011, that it is said that the share issuance is void.
Thank you.
Yesterday, my Lady Rose asked Mr. Crowe a question, the substance of which was about whether or not the appellant stepped into the shoes of WKN and that the appellant was therefore entitled to participate in the company. The parties have been busy overnight. I am told that Mr. Crowe is going to refer to a case in reply from McMahon J in the Alberta Court of the Queen's Bench Division. I've obviously no objection to him doing that. It is said that he wants to do that to give you an illustration of a case where equitable principles have been held to apply in relation to the surviving spouse of a deceased shareholder.
Yeah.
I agree that it does seem to be an illustration of that fact. I will leave Mr. Crowe to show you that. I have one sentence to say in response, which I can either say now in advance or I can say it once he's taken you to the case, if that's what he's going to do.
Well, I think it would, if you don't mind doing it now, it might be best to do it now, just to avoid an endless complication at the end of the morning. I
don't think Mr. Crowe is going to be particularly objecting to this on the basis that all I was going to say is there doesn't seem to be any reasons given by the judge for what he said. Now, obviously, you know that we say there never even was a quasi-partnership between the three brothers. Can we assume just for a moment that there was? In addition to the case that Mr. Crowe has found, we have found a number of cases which we say show two things. Firstly, rights under a quasi-partnership, i.e. equitable considerations, are not transmissible and would not continue to bind the remaining quasi-partners after the deceased quasi-partner's death, let alone the deceased's heirs. And the second point that emerges from these cases, we say, is that a quasi-partnership is a personal relationship and does not survive the deceased partner's death, save where there is an express provision in the company's articles that the heirs of a deceased quasi-partner would have the same rights and benefits as the deceased. Now, we've had to obviously put these into little bundles. There are 5 of them here. I don't propose to take you to any of them myself right now. What I would suggest, however, is that you start with a case called Ting Shui Ping. That is a 2016 case from the Singapore Court of Appeal, and I believe it refers to most of the others, if not all of the others, in the little bundle that we've put together for each of you.
This is, I hope, an electronic bundle.
It's not an electronic bundle at the moment, in the time in which we've had. We will make it one.
Perfectly all right, Mr. Arizona. Could you take time and electrify it for at least me? Well, it may be my colleagues are all perfectly happy to have it in paper, but we move around a bit and it helps to have it portable.
I quite understand. I only did it so that if you wanted it right now, I could give you something.
I would like it right now. Would it be possible?
Oh yes, by all means, let's have it both. If you've got a photocopy,
they are here if you want them, and we will certainly get it put into electronic form.
We will be most grateful.
That will happen. The third point I wanted to raise yesterday was that my learned friend Mr. Crowe submitted that there was a restriction on the transfer of shares in WTK Realty. And where my Lord Stevens mentioned that it can't be true that the holding company has a restriction but not STIC. There isn't, we say, a restriction on the transfer of shares in WTK Realty either. And we say that because Article 4 of WTK Realty's Memonarts says that shares shall not be issued to transfer a controlling interest in the company without prior shareholders' approval. And Article 24, sorry, I should have given you, Article 4 is at 2679. Article 24, which is at 2682, provides that members may transfer any or all of their shares, but every transfer must be in writing in such a form as the directors may from time to time approve. Ernst & Young.
But is it your case that the ordinary shares which, as it were, emerged from the conversion were not issued, subject to Article 4?
They probably were issued. Yeah, they were issued, but the question is, did they transfer a controlling interest? Now, of course, that's going to lead you straight into who rightfully had what at the relevant time, before you can make a decision as to whether or not it's a controlling interest. And of course, we would say if it stays as things are at the moment, the issuance to STIC would not be the transfer of a controlling interest.
The issue of the realty?
The issue to STIC, sorry, my lady, of the realty shares would not be the transfer of a controlling interest.
Just as a matter of interest, could somebody point to the number of the record that contains the resolution of the 28th of March 2013 of STIC? The board resolution about... Don't look for it now, because you've got many people who can help you.
Ernst & Young have now been contacted. I understand that they were not contacted before. The partner has been asked whether there is any record of STIC at EY. She said that EY only keep their records for 7 years. She also said she would check their records nevertheless. They checked, and they confirmed that they don't have any records of STIC.
Now, which was that, the Trust Corporation or some other part of it?
Ernst & Young, as I understand it, were responsible for, I think my Lord Stevens indicated that they were involved at the time when either the STIC was incorporated or at the time when the CPS were created. I can't remember which one, but obviously Ernst & Young have checked to see whether they have any records of STIC, and they haven't.
And sorry, I was asking which entity is Ernst & Young for that purpose? Are we talking about?
Do you mean where it is?
No, is it the auditor or is it the trust corporation? Because they can't be both in the same.
I believe it's the auditor.
Well, then you would be asking the trust corporation.
Well, we better ask the trust corporation as well.
Yeah.
I will get that done, and, well, those behind me can hear.
And if the request and the reply are in writing, you would presumably be disclosing copies to your opponents.
Yes, I mean, my lord, yes. I don't believe either the request or the reply was in writing, but I'm sure we can get it put into writing if that would help everyone. Just before I go back to substratum, there's one thing that I missed in relation to quasi-partnership yesterday, and that is the period of time from the death of WKN onwards. Because at paragraph 65 of our written case at 9359, you'll see that the appellants allege that WKY and WKC had actually entered into a quasi-partnership with the appellant. And we said, obviously, whatever the position was before WKN's death, there certainly was never a quasi-partnership after the death, or that was created after the death. Indeed, we'd say that is not even arguable for reasons which, I mean, we set it out in paragraph 65 of our written case, but if I can summarize it, paragraph 66 of our written case, if I can summarize it, the facts include this. The appellant accepted in cross-examination that there was no evidence to support the notion of her entering into a quasi-partnership with the appellants, with the respondents herself. They also include the fact that the respondents and the appellants had not seen each other since the appellant left Cebu in Malaysia in 2003. And they also include the fact that the appellant did not refer in her witness statement to having had any discussions with either WKY or WKC in March 2013, so immediately after the death of WKN, or to have having had any discussions with either WKY or WKC about how STIC should be run. So that takes me back to, we were looking at substratum at the end of yesterday, and right at the end, my Lord Briggs asked a question. What I'm going to do, my Lord, if I may, is just finish the point I've got on substratum and then immediately go to explain what the problems will be in relation to the winding up of STIC, were one to make a just and equitable winding up order at this stage. And indeed at the stage where STIC was in a position it only had a cash pile in those at that time.
Could I just, before we leave the articles, at page 268, quite sure what the page number is. (2682), Article 28. Does that give us the directors power not to register at their complete discretion? Is that right? And
I mean, they would have the power to do that, yes.
And the directors are all family members, are they?
The directors of WTK Realty, I believe, are all family members. Yeah. Can I just double check that that's right? Yeah. They're all family members. Yes.
Thank you.
Is there anything in the articles that explains on what basis they might decline to register a transfer other than the suspected fraud?
Very good question, my Lord.
Again, by all means, just ask someone to have a look and come back in due course.
Is that only returned to the person, is it?
I think it's 27.1, isn't it?
27.1.
They seem to have a very broad discretion.
Yeah, sorry, it's 27.1 it is.
My Lord, my understanding of it was that there was nothing that actually explains the basis on which they could, in fact, decline. I mean, my lady, the resolution to convert is dated the 25th of March 2013. It's 3860 and 3861.
Thank you.
So if there was a winding up of STIC and a distribution of the shares, the directors of Realty could refuse to register them.
Sorry, my Lord, I'm sorry.
If there was a winding up of STIC
Yes.
and the liquidator distributed the shares 1/3, 1/3, 1/3, the directors of Realty could refuse to register them.
Well, I think the answer to that question must be yes, my Lord.
Yeah.
Subject, of course, to any jurisdiction of the court.
Of course. I mean, if there's a way in which the directors can be compelled to do it,
Yes.
then obviously, you know, that could be taken advantage of. But I think, strictly speaking, on the wording of it, it does look as if they could refuse to do so.
It's a power which would be subject to the, well, if it was an English law power, it would be subject to the Howard Smith and Ampol constraint. Although I'm obviously cautious about making any unproven assumptions about whether Malaysian law follows English law in that respect.
Yes, I don't know the answer to that, my Lord, but I mean, Malaysian law, certainly in the parts where I've run into it, seems to be not dissimilar.
Yeah.
Now, I was on, the appellant says that by the time of the conclusion of the trial, STIC had lost its substratum because Realty had been wound up. And I'd made the point about this was on the last day of the trial, an appeal was bound to follow, there's no certainty, and the like. What I was then going to do was to give you, or to look at an illustration, to look at it in a little more detail, to see how we would say STIC hasn't lost its substratum if WTK Realty is wound up. Let us suppose that all appeals are lost and Realty remains wound up. I mean, we would say the realisation process will obviously not be done overnight. It's likely to take years, especially given the high-value nature of Realty's asset portfolio. Of course, along the way, the liquidator of Realty will need to make many decisions with respect to the realisation of the underlying asset portfolio, and he will inevitably consult Realty's shareholders, as indeed he should, before taking commercial decisions. That being so, as one of the shareholders, STIC would obviously have a continuing role, indeed we would say an important function, notwithstanding that Realty has been wound up. STIC would be entitled to exercise its voting rights in Realty's liquidation. It would also be entitled to be consulted and to assist in coordinating the strategy for the liquidation. I mean, of course, the majority shareholders of STIC would not be entitled to do things which were unfairly prejudicial to the minority in the context of that decision-making process. We would say that's the whole point of being a majority shareholder. The minority are not entitled to control the process. That is a necessary consequence of being a minority shareholder. And against that background, we would say that you can see that STIC doesn't lose its substratum immediately upon the making of a winding up order in relation to Realty.
Can you just remind me what proportion of the Realty shares the STIC holding represents?
14.4%, I believe. 14.4%.
Which is
275, approximately 2.75 million shares. Okay, I'm sorry, it's not approximately, it is 2.75 million shares.
So STIC has 14.4% shareholding in Realty.
Correct, my lady.
And that shareholding either holds the balance of power if the Malaysian courts are overruled on the two void issues, or it doesn't.
That must be right.
As I understand it.
Yes, I think, my lord, that must be right.
Yes, I think that's common ground.
Yeah.
Yes.
Now, obviously, we say that winding up STIC, it's been put against us that it doesn't cause us the slightest difficulty or inconvenience. We would say it plainly will. It will mean that somehow the appellant, as a minority shareholder, has taken away the right of the majority shareholders to be in control of how those votes are used. Now, obviously, again, I stress, the majority could not use those in a manner which was unfairly prejudicial, because then in those circumstances, immediately, the minority shareholder could take action, which I think...
If Realty's in liquidation, it couldn't anyway, could it? Because the liquidator's not bound by what its shareholders say in response to consultation.
Well, my lord...
The liquidator would probably go to court and the war would continue in the Malaysian High Court.
Well, I was going to add, actually, when one looks at STIC, if you wind it up, and we're going to come on to that in just a moment, we're going to have exactly the same problem if STIC itself is placed into liquidation here. In fact, I might as well come straight on to that as what happens if you have a winding up of STIC. If that happens, the very first thing that would have to be decided would be who is going to be the liquidator. On past experience, I think it's unlikely that the appellant and the respondents would agree about that. But the appellant's minority shareholding doesn't obviously enable her to choose who she wants as liquidator. So if there is a disagreement, we are going to be, it is most likely that the matter would end up before a court.
Yes.
Whether that would be on our application or on the appellant's application, I suppose, would depend how the liquidator has actually done this. If he says, well, I'm doing it because I'm going with the majority, it would no doubt be on her application. Obviously it's a bit difficult to predict because you don't know who the candidates for the job might be. But it's highly likely that it would be contested between the parties and that a judge in the BVI...
It's highly likely, isn't it, the court would appoint a wholly independent professional having no prior connections with either side who could be trusted to operate in an independent way.
My lord, I can well understand that might be the outcome that was actually reached.
Both in Realty, in the sense that's surely how the Malaysian court would operate, and in the BVI, because that's how the BVI court would operate in relation to STIC.
Yeah, my lord, that is obviously one solution that the court might adopt. I can't predict that the court would adopt that. If you get a liquidator who's proposed from Ernst & Young on one side, and you get a liquidator who's proposed from a one-man band, there may be an obvious conclusion that you go with an Ernst & Young liquidator, or I
wasn't making a big firm point, Mr. Alexander. I was just making a professional independence point.
No, well, my lord, I can quite see how the matter might get resolved, but it might not be. And if that happens, well, you can see what will happen thereafter. We've already experienced it. We've been through the Court of Appeal and we've come here.
Yeah.
But then let's look a little bit further ahead. Once there is an uncontested liquidator, what happens next? Obviously, the liquidator would have to decide what to do with the assets of STIC. Two options. Certainly, there are perhaps more than two options, but certainly one possibility is a distribution in specie. I think that was mentioned yesterday. So you'd get a situation where WKY and WKC would get 66.6%, and the appellant would get 33.3%. Alternatively, you could have a situation where the liquidator tries to seek rival bids for STIC's assets. That could just be from the parties, or it could be from outside third parties, or it could be a combination of the two, doing what a liquidator is supposed to do, which is to realise the best price that he can actually get.
It seems awfully unlikely that an outside third party
Well,
spend money buying itself into this.
I agree with you. The likely candidates for this are going to be the parties represented on this appeal.
Yeah.
How does that dispute get resolved? Well, we're going to be the usual way in which that is resolved, I would suspect, which is if the liquidator is sensible, he's going to apply to the court for directions as to what to do, and he's going to make both the appellant here and the respondents parties to that application. So we'll have another potential dispute to be resolved by the court in BVI, with the prospect of that, of course, going up to the Court of Appeal and possibly back here.
Is one possibility this, Mr. Alexander? Assume the assumption which you're inviting us to make at the moment is that in the end, Realty goes into liquidation. That's the sort of working assumption we're looking at.
Essentially, because it was part of your lordship's question yesterday.
Yes, absolutely.
Yes.
Although I appreciate your submission is wider. Is a possible way in which the court should approach the case that the lead court, if you like, in which the future of this family business is being considered and litigated is the Malaysian court, and that it would be appropriate for the BVI court, which has jurisdiction over one quite small and mechanical part of the empire, to wait, as it were, and find out what's happening with the main company before deciding either by way of an outcome of this appeal what it should do, if it was minded to think that the appeal should be otherwise than just dismissed, or in the context of an ongoing situation within STIC, by which I mean a buyout situation or a liquidation situation.
Well, Lord, I can't say it's not a possible situation. Of course it's a possible situation. What I also can't say is it a situation which one or other of the parties here would in fact say, well, I don't like that answer, so I'd like to go to the Court of Appeal and back to the Privy Council. I mean, I sort of kind of suspect I know what the Privy Council might say in circumstances that you've just posed, but that doesn't mean it won't happen. And of course, there are other things that inevitably could happen. And now that just leads us to, obviously, a winding up of STIC will only increase the costs and expensive for the parties to the present appeal. But it will also, I mean, I'm talking about their own costs, if you like, that they have to spend to deal with that. But it will also lump on the parties an additional set of costs, being the costs and expenses of the liquidator and his or her legal advisors, and that will, of course, reduce the amount available to the respondents and the appellant in the liquidation.
So would it avoid the valuation exercise. It would, in the sense that either the shares are distributed in specie or they're sold, in which case the value is then determined. So what I think is what you're saying, there would be all these costs. They may or may not turn out to be less than the costs of a disputed valuation exercise, which we will know from experience can also be very expensive and time-consuming.
I mean, I quite understand. Of course, the cost of evaluation can be expensive and time-consuming. I mean, I don't think I can answer the question because I don't have a sort of crystal ball for this one. What I think I can say to this is, if you have a winding up, there is the potential for a number of possible applications having to be made that could be, if you like, run up the ladder. And that is where you go to the valuation side of this. And I mean, my learned friend says that a winding up is the solution to all the problems. In the past, he's called it, I thought it was a rather good analogy in one sense, cutting the Gordian knot. The only problem is, in relation to this lot, it won't cut the Gordian knot because you can see there's a potential for a number of other things. What, on the other hand, does bring this to an end is if you have a valuation. Now, I appreciate that a valuation is going to be expensive, but you may avoid a liquidation altogether, so you may be losing those costs. You obviously have the valuation. I mean, each party in those circumstances has a choice as to how much they wish to spend on dealing with this valuation. Now, I, of course, have to accept the valuation could be going up to the Court of Appeal and coming here as well. But that's an end of it. That is the end. So, if you like,
well, it could come twice, couldn't it? It could come at the stage when, if this appeal is dismissed, the BVI court would have to set the valuer's brief, as it were, what would be the terms of the valuation, and it could come again if one or other parties or both were dissatisfied with the valuation.
I suppose that is technically possible, yes, my lord. But what it does do is it means that we all know that there is a finite amount of litigation that constitutes the worst case scenario. Ultimately, if you do have a valuation and a buyout, then in those circumstances, there is nowhere else to go. Whereas if you have a liquidation, it is a somewhat open-ended, or at least creates the possibility of an open-ended number of pieces of litigation.
Well, isn't the possibility that the valuer won't be able to get access to the documentation which he needs, or that there is information which he doesn't get and doesn't know exists?
Well, my lady, can I answer that in this question? I was going to come on to that later, in a moment, which is obviously, what are the, if you like, downsides of this that have been put forward on behalf of the appellant. Mm-hmm. I mean, the first thing I would say in relation to that is this is a myth, the appellant being under any disadvantage in relation to valuation, because documents are said to be with WKY and WKC. First of all, the necessary documents, at least in theory, will have to be produced in response to court orders if they have not already been produced on a voluntary basis. But there's a much more important point here.
At some stage, you'll deal with the cross-border problem, I hope, because the kernel of the valuation is going to be working out what Realty's worth.
I understand that.
Realty's is a company carrying on business in Malaysia and elsewhere. Its documents are all in Malaysia. Nothing's in the BVI, and the BVI wouldn't have effective injunctive control on people with documents in Malaysia.
I totally understand that, but the next point I'm going to come to is that WTK Realty has as two of its directors who are entitled to cause documents to be produced to them as directors, Mimi Wong and Neil Wong. And they are, of course, the children of the appellant.
you saying that they should use that power for the purpose of in their capacity as shareholders of STIC? It is a fiduciary power.
I'm sorry, my lady. Are you referring to the appellant using it?
No, you just mentioned Mimi and Neil.
Yes.
Who, as directors of Realty, have access to the accounting records.
Yes.
I haven't actually seen the section which gives them that right. And if they were to exercise that power in order to benefit themselves as shareholders, or rather their family as shareholders, in STIC, would that be said to be a proper exercise of their directors' powers? Because if it isn't, then the company, Realty, will be able to say, no, you're not going to get access to that. That's not something you're entitled to.
I understand the point, my lady.
So there'll be a sort of satellite litigation going on.
I ought to just add, in the case of Neil, of course, he is a substantial shareholder himself, because he was given 800,000
But how do we know
shares.
Whether shareholders, pure shareholders, have any greater rights to access to documents in Malaysia in relation to a Malaysian company than apparently a minority shareholder does in relation to documents relating to STIC in the BVI?
Well, I don't believe we have any evidence in relation to that. Would your lordship give me just one moment? My lord, there is no evidence of that, but what I am being told is, since they are on the board, they have access to documents in the same way as one can turn round and say that we have access to documents because we're on the board and because we're shareholders. So the position is absolutely the same for both of us. You're also going to have a situation where the BVI court is just going to turn around and say, if it's not satisfied that the documents are being produced, I'm not carrying on with this. I'm not carrying on with this until these documents are produced.
And in a sense, they all chose to set this up in the BVI for tax reasons, and that has benefits and burdens, and they've had the benefits, and it may be that the burden is that the winding up of it is a lot more problematic than it would have been if they'd kept it all in Malaysia.
Well, I don't know. It may have exactly the same problems in Malaysia, given that, as I said earlier, I mean, at least some of the provisions are pretty similar to us in the sort of winding up sort of field. But yes, I mean, that is absolutely right.
But thus far, the buyout is a remedy which has been granted to the minority in STIC. So it would come as little comfort to the minority for the BVI court to say to the majority, well, if we're not satisfied you produce the documents, we're going to stay the buyout.
Well, the court may take a different view, which is that I'm going to look at the last set of accounts and say, at a minimum, this is 36 million, right? The value of these shares. Now, if you say it's less than that, you better produce some pieces of paper that show me that. And I mean, look, I mean, at the end of the day, obviously, these people have a vague idea, being on the boards of Realty and STIC, as to what the true value of STIC is. Of Realty is. Realty publishes, I think, give me a second. Realty has to file with the Registry of Companies accounts on an annual basis. So unless the accounts are being completely diddled, and you would have thought that a director might turn around and say, well, that just doesn't look right to me. And
the valuer may need information which is not in the accounts, e.g. profit projections or management accounts in Realty. That's what it's valuing, this.
I quite understand that. I would say that to the extent to which we can get them, they can get them. We're in the same position. We are directors. We are shareholders. If we can get it, well, they can get it.
Thank you.
If the final question for you, just want your submission on it, Mr. Alexander. Thus far, the BVI court has ordered a buyout.
That's correct.
if because of obstruction in the provision of information, the BVI court came to the conclusion that the buyout simply wasn't working, would it be able to revisit its decision to order a buyout and order a winding up?
Well, I don't know if it could be do it quite as simply as that, but it probably would be able to I suppose the answer is you could go back and have the order undone. I would have thought it's fairly unusual.
Yes.
In the alternative, I suppose, it may be at that stage that you just do the straightforward thing, which if they'd really wanted a winding up in this case, is you actually present a winding up petition. And you go on the basis of just and equitable without having to show that there is unfair prejudice. And that might be rather a simpler application if you're in a position to say, look, this is what has happened. These people are being obstructive to this. In those circumstances, it's just and equitable that this company really should be wound up. Now, then, if you like, that would be acting as a form of interorem to the respondents to ensure that all available documentation is actually provided.
Thank you. I'm sorry, we've taken you out of your course.
Not really, actually.
In a big way.
Not really. I've actually got. I've actually got. Your Lordship asked me a question right at the end of last night. The question you asked me was: assume that Realty was wound up, i.e., that the appeals were either abandoned or failed, and assume for the moment that there was some cause of action or some reason for the court to have a discretion whether to order a winding up of STIC or a buyout. Do you submit that a buyout would have any logic in the context of STIC becoming, at the end of the winding up of Realty, simply a company holding a pile of cash in lieu of shares? My Lord, even on those assumptions, we'd say yes. And we'd say that on the basis that you would have avoided all the costs of the liquidation of STIC with the sort of applications that I've already foreshadowed and their ability to go up the ladder. And not only are we talking about the costs of the liquidator and his or her lawyers, which is the primary thing there, but, obviously, the parties themselves are going to throw away, as a result of continual references to court, whenever the liquidator wants to make a decision, significant funds if they disagree. And what's more, you're going to avoid the pressure that repeat applications to the BVI court will place on it.
But if STIC was a pile of cash, could there really be a contentious liquidation? There may be issues about tax, but apart from that, it would just be distributed, wouldn't it?
Well, my Lord, you would certainly have a liquidation. There may be a row straight away as to how that ought to be distributed. I see it's possibly easier.
There's no dispute, is there, as to the relative shareholdings or within STIC?
Within STIC, no.
No.
It's two-thirds.
It doesn't have any. Well, it may have creditors in the form of a large number of lawyers, some of whom are here today, but apart from that, it doesn't have large creditors.
As far as I'm aware, no.
Are all the shares in Realty now the same kind of shares, just ordinary shares?
I believe so, but I'm going to double check. Yeah, I think all the same shares, ordinary shares. No other types of shares. No other types of shares, my lady. Now, can I then slightly rejig? You've asked me if that was, you had a winding up at the time when there was already, if you like, a pile of cash in lieu of shares.
Yes.
Right? But we're not there by any stretch of the imagination. What we have at the moment is, let's assume there's a buyout. As I've said, we end up having to pay the appellant out with, I would hope, limited recourse up here, and then that's it. That is what is a clean break in this case. There can be no further room, there is no further room for argument. And indeed, once we have done the buyout, there is also no need for a contentious liquidation at all. By contrast, we would say that the winding up now of STIC does not bring about a clean break at all. We'd actually take the view it would make matters much worse. It would bring what I think we're learning from Mr. Crowe referred to as the curse of litigation. It's said that there's no prejudice to the respondents. Well, in fact, it brings about quite a lot of prejudice. It brings about effectively a double whammy of costs, funding lawyers to deal with the applications that the appellant makes, but at the same time, it's reducing the value of the assets of STIC because of the liquidator's costs. And one asks, put the boot on the other foot. What is the downside of a buyout for the appellant if Realty is in liquidation? Well, she's going to get paid what she should have, and she's going to leave. And that's, if I could put it bluntly, sort of the end of the story vis-à-vis STIC.
Well, I imagine she apprehends that the buyout might be on a discounted minority basis, whereas a liquidation wouldn't.
Well, I
imagine that's why we're here.
I mean, I don't know the answer to that question. I don't think it's ever been put like that. And I suppose at the end of the day, that is going to that will have an influence on any valuation proceedings. Look, that was all I was going to say in response to your
Thank you very much
to your question last night. What I was going to do next, okay, is the shareholders' agreement. This is the first part of the issue raised at paragraph 35.2, little Roman 3, on 9267. And that is whether the STIC resolution to convert the CPS and the subsequent conversion were in breach of an agreement or understanding that this would not be done in the absence of unanimous consent of WKY, well, the two individual respondents and the appellant.
Mr. Alexander, Mr. Crowe hasn't said anything about that orally, but he adheres, of course, to his written case about it. And we have all read your written case about it. So you may want to take issues where Mr. Crowe hasn't joined the lists orally reasonably economically.
Well, my Lord, we have set out the position.
You have, yes.
In paragraphs 82 to 88 of our written case at 9362 to 9364. What I was really going to say was, if you read that, you'll see that there was positive evidence that there was no such shareholders' agreement. That's paragraph 82. And in substance, no evidence whatsoever, either from the appellant, who actually had no personal involvement in STIC at all, and indeed, if you have a look at her witness statement, doesn't even mention any alleged shareholders' agreement in her witness statement at all, or otherwise, there was no evidence at all to the effect that there was such a shareholders' agreement. And one can then add to that, if you look at what we say, that when the appellant put the case about the shareholders' agreement in the present case, it was materially different from what she'd said about the position in the earlier Malaysian proceedings. So I think where we get to was there was no evidence before the judge which could have enabled him to form the view that there was the alleged shareholder agreement, other than a bare assertion from the appellant. And obviously, the judge saw the witnesses and decided that there was no shareholders agreement. That's enough of the shareholders' agreement then. The family agreement. Again, I think we can probably take this one relatively quickly. This is allegedly related to a meeting on the 6th of December at the Wolper Jewish Hospital in Woollahra in Sydney, where WKN was. The appellant originally put forward one version of an alleged agreement between the brothers and Neil Wong, and that case was just obviously wrong. WKC said so in his evidence, Janice Ting said so in her evidence because she was there, and then, astonishingly, in an email dated the 15th of December 2012, so the meeting was apparently on the 6th of December 2012, at which this so-called family agreement transpired, but you then get an email dated the 15th December 2012 from Neil Wong, so the appellant's son. That is at 3765 to 3766. And in that email, Neil Wong actually said that nothing had been agreed at the meeting on the 6th of December, except that some valuations should be obtained. His words were, there is no agreement in place except getting valuation organised. So eventually, after disclosure, the appellant abandoned that case and gave a different version, but the new version, we said, was wrong as well, and there were reasons for that, such as, of course, the appellant wasn't at the meeting on the 6th of December. Neil Wong was at the meeting, but he did not even give evidence at the trial, even though he sat in the courtroom throughout the trial supporting his mother. Obviously, WKC and the appellant, WKC said that what the appellant said was not correct, so did Janice Ting, and there was actually not a single document supporting what the appellant alleged. So we say you can hardly criticise the judge for having decided that there was no family agreement. Now, those are the only two things that I'd call agreements that are said to have been made. Of course, we saw yesterday there are the allegations at paragraph 39 of the respondent's statement of claim that we looked at. That's 214. And you'll remember there were 6 subparagraphs, I think it was A to F. And the fact of the matter is, there was no evidence to support any of this at all. I mean, in fact, it actually came down to the appellant also saying that she didn't actually have any knowledge as to how STIC ran at all. That you get from 7588 at lights 3 to 6. And so far as we've been able to tell, that is it as regards informal agreements that were said to exist. So we'd say that there are none on the facts there are no agreements on the facts to enforce as a matter of equity or otherwise. That then brings me to the second question posed at paragraph 35.2, little Roman 3 of the SFI, that's 9268. Namely, did the resolution and subsequent conversion unfairly exclude the appellant from participating in STIC? Again, we've dealt with this at paragraphs 91 to 93, at 9364 to 9365. We actually said that this was a point that we didn't seem to have been pursued by the appellant with either the judge or the Court of Appeal, and with the consequence, I don't think either of them ruled on it. So our primary position is that having failed to develop or pursue that point with either of the courts below, it's not really open to the appellant to seek to develop the point now. In any event, we said that the suggestion that the conversion resolution or the resolution itself unfairly excluded the appellant from participating from management. The conversion resolution related to the conversion. It didn't have anything to do with whether the appellant could have participated in the management. The same is true of the conversion itself. Nobody excluded the appellant from participating in the management of STIC. The appellant was just never a part of the management of STIC. We said the fact that the appellant had never participated in the management of STIC was not unfair because we'd never agreed with her that she should participate, and we had 2/3 of the shares in STIC, so ultimately we had overall control. The next thing I'm going to go to is improper purpose. That is paragraph 35.24 of the agreed statements and facts of information. It's page 9268, and that is whether WKY and WKC exercise their powers to convert the CPS into ordinary shares in realty with a substantial primary or dominant purpose of diluting the voting rights of the estate and the appellant's family and or increasing their own combined shareholding and voting rights or control over realty, and hence for an improper purpose. Now, this really is a question of fact that the judge and the Court of Appeal made concurrent findings on. The judge determined that the conversion was for the predominant purpose of replacing the credit facilities which were about to expire. The Court of Appeal determined that the judge was not blatantly wrong in deciding that the decision to convert was for a proper purpose, and indeed itself concluded that conversion was for a proper purpose.
Well, you very kindly gave me the reference to the 2 resolutions which were passed by STIC. How do we know what the purpose was from those resolutions?
Well, you don't get it from, my lady, absolutely, you don't get it from the resolutions. Mm-hmm. What you get it from is the fact that the people who were involved in that, so WKC and Janice Ting, came to give evidence. They gave evidence in relation to it. There are documents, which I'm going to come on to in a second, which plainly show that Realty had credit facilities with 2 banks, that from the autumn of 2012, those banks sought to get Realty to comply with more.
You're going to be dealing with that, so can I just cut you short for a moment? Firstly,
yes, of course.
Janice Ting can't give any evidence about the board of STIC, can she? She says, I do not know anything about STIC. Well, that's recorded in the judgment.
Oh, I see. Okay.
She can't, because she's CFO of
WTK Realty.
WTK Realty. So she doesn't know. She can't help us on this. Why? What about Mr. Lowe? Where's his evidence? He was the person who voted on this. He was the sole director of STIC.
Well, my lady, I have to accept he did not come.
Well, how do we know what the purpose was then?
Well, the only purpose can be gleaned from, WKY and WKC are held as being de facto directors of STIC.
Well, that's not something they accepted, I don't think.
Well, I'm not sure there was ever really any major argument about it. I think they did say formally on the pleadings, we don't agree, mm-hmm. And the judge just took it they were de facto directors.
But how does that help you?
Well, that helps me in the sense that if they were de facto directors of STIC, they know precisely for what purpose STIC carried out the conversion. They
weren't at this meeting. They're not shown as present. It's just Mr. Lowe.
Oh, you mean at the time of the board resolution?
No, that's the critical documentation. That's when the decision is made.
Well, yes, my lady. Other than the fact that obviously it's been held against us on numerous occasions that the real decision makers who get Mr. Lowe to make that decision are WKY and WKC.
Well, is the court to assume that Mr. Lowe is a mere cipher, that he simply acted as he was told to by shareholders, in which case there wasn't a proper exercise of the director's powers?
Well, I don't know the answer to that question, Mary, because he didn't give evidence.
Well, I mean, could it not be said there's an error in law in the way the Court of Appeal, could it be said the Court of Appeal has gone about this question, because it's saying that what the purpose of the conversion was what we deduce it to be, not what the director took it to be. And when it says in the section 121, directors must act for the purpose of the company, that means looking at their purpose and assessing whether it's proper. And then it said that test is objective. But it's not for the court to speculate about the purpose. The purpose has got to be, there must be evidence about the purpose of the directors.
Well,
as opposed to the directors of Realty, or the shareholders of Realty, or the shareholders of STIC.
Well, we did have WKC here. He did give evidence. The judge found him to be a credible witness on the things that mattered. On the basis that he's a de facto director, I appreciate that the resolution doesn't actually record what it is, but if you went through the chronology and you followed what had happened there, you could easily see that they were going to lose credit facilities and that they...
Well, who's we?
WTK Realty.
Yep. But it's not STIC. STIC is going to have to put its hand in the pocket for 2.2 million ringgit, and it's going to have to convert. Now, what is the direct benefit to STIC? Because it could always convert at any time. It didn't have to do it that moment. So looking at STIC as an independent company, what was the benefit to it?
Well, STIC cannot have one of its, if you like, not subsidiaries, but a company in which it holds shares, defaulting on the loans from the banks. Mm-hmm. That is plainly not in STIC's interests.
Did STIC say, well, what other proposals have you got? Or what other ways are there of meeting the bank's conditions, other than us having to pay this 2.2 million for equity? I mean, there seems to be no reasoning in the resolutions you've pointed me to.
Well, I agree. The resolution does not say what it was, and what the judge did was he took it from the witnesses who gave evidence. Now, I appreciate, Milady, that Janice Ting may have been only the CFO of WTK
Yes.
Realty, but as you appreciate, that is the main company in the group. It's I think they call it the flagship company, and in those circumstances, she's going to know exactly what STIC's purpose was in doing this. Indeed, it was her who actually proposed the whole thing in the first place. So she can certainly give evidence as to what happened
She can say, in effect, I could see this is what we wanted to do within Realty, and I asked STIC to do it.
Exactly.
It goes that far, but it doesn't go further to answer why STIC actually did do it, unless it's just an inference that they did it because they wanted to accord with her request.
Well, I think that's what you get, probably as a maximum, out of the judge's judgment.
Yeah.
Is that he went through the thing. And fundamentally, the question that was live here was it done to meet the concern about the two facilities that were going to expire, or was it done for the purposes of ensuring that, as the appellant would put it, for the purposes of ensuring that they had a majority over her? Mm. I mean,
do you accept that that second purpose would be an improper purpose?
Sorry, my lady, do you mean, do I accept that if the appellant's version is right, that would be an improper purpose?
Yes.
I think I have to, yes.
Yeah.
And was there any written explanation from either Janice Ting or whomsoever as to why STIC should vote in this way? Where do we turn to in the PDF to get the instruction to STIC?
There is no written instruction to STIC, is there?
And where do we get the oral communication that took place prior to the resolution being passed?
Well, what you have got is the minutes of the board meeting, which I'm sure
I
you've seen.
appreciate that. But is there any evidence of an oral communication?
My Lord,
Yes. Well, don't, if someone could come back at some stage.
Can you just put it together on a piece of paper for me, and I'm going to get it given to me on a piece of paper.
Good. Thank you
Just
very
to
much
make sure I actually get it right.
Yeah.
Could I just then ask you about the judge's finding at page 87, subparagraph 8, where he says, and this is the critical finding as I understand it, the resolution to convert the CPS and ultimately the conversion were authorised by the company and for a proper purpose, as together they facilitated WTK Realty's compliance with the conditions of the offer from Bank. I think that's all I need to read from that sentence. Well, that's not of itself dealing with the question. And then it goes on, although there is no evidence that consideration was given to the interest of STIC, the conversion benefited all the beneficial owners of STIC, who are also shareholders of WTK Realty. Well, that's accepting the argument that the resolution wasn't discriminatory. That's your point, isn't it? That the conversion would operate for the benefit of everybody equally.
Yes.
So it doesn't say in that sentence what the benefit was to STIC as a separate legal entity.
Which paragraph were you on?
Page 87.
Oh, I'm so sorry.
Subparagraph 8. I think this is the only finding, unless you can find me something else. But he doesn't.
I've got a feeling there might be another one.
All right. I'd be grateful to have my attention drawn to that, because this doesn't seem to be dealing with the position of STIC as a separate legal entity.
Well, I mean, it certainly says that they were authorised by the company, but it doesn't go any further than. It doesn't go any further than that.
Mm-hmm. I mean, there may be something I don't know about.
No, Melody, I'm sure you may be right in relation to this. I mean, it's obviously quite a long judgment. I can't put my fingers on it immediately, but I'm going to ask that. Is there anything else apart from?
There was no separate consideration of STIC's interests. Would it be possible to say that the powers were exercised for a proper purpose within Section 121?
Well, I suppose it entirely depends. We don't have the evidence of Mr. Lowe. It entirely depends on what happens between Mr. Lowe and either WKC, WKY, and or Janice Ting. We don't have that.
Thank you very much.
There's something at 138 on page 77, which I think is the evidence of Ting as to what she told the board. I assume she means
Realty.
I'm not sure whether she means the board of STIC or the board of Realty.
That's a realty meeting, isn't it?
I'd read that as meaning the Board of Realty.
I think it's the Board of Realty, that one.
And that was, she was a realty person and considering the interests of realty and addressing the board about the interests of realty, presumably. Or maybe the interests of the family, who knows, but... I'm not quite sure how the offset works in the next sentence. Because if STIC owed money to realty, how did that offset the STIC liability to stump up the issue price? Unless there's a typo and it means the offset was the other way. I mean, the 2.2 million due for the shares at conversion meant due from STIC, didn't it?
Yes.
Well, if STIC owed money to
STIC owed money
that
to
be
realty.
offset against an additional sum of money which it would owe on the conversion. I can quite see that if realty owed money to STIC, then there'd be a set-off.
Well,
I mean, I appreciate that if one reads the whole paragraph, she said that approach had to change and there did have to be real cash. But it's still it's a very odd sentence.
well, I mean, yes. I mean, ultimately, it had to be cash rather than...
Is it just a typo? Should it have been realty to STIC? And we must know what the state of account between STIC and realty was at that stage.
Well, I'm sure I can find out. I don't know off the top of my head.
Going over your head. I've only just dropped it on you, Mr. Alexander, but you've got an enormous team, and STIC's here with an enormous team, so somebody can find out what the state of account was between STIC and realty, surely.
I will ask.
Thank you.
I have asked through my law.
It'll be recorded in the accounts.
Well, I mean, look, I'm not sure I can take this much further, other than saying, look, ultimately what the judge had to do was to make a finding between the two versions that were put forward as to what the purpose of what the purpose was. If the purpose was for what the appellant says it was for, well, then it's an improper purpose.
But if it was the purpose for which the judge found, you simply say, well, that benefited STIC because what was good for realty was good for STIC.
Well, and it's very good for STIC, actually, because what STIC ends up with is, instead of some CPS that have been paying historically ringgit 27,500 per annum, which is the equivalent of 5,500 US dollars. It ends up with an asset, which we would say is worth 36 million. So, I mean, there is no doubt on the numbers that STIC was a massive positive gainer as a result of what happened.
Well, it could have done that at any time.
I mean, yes, it could have done that at any time, but it was thought to be necessary to do that at the time in order to fit the requirements of its subsidiary to be able to raise the 19 million to replace the SCB and the HSBC.
We don't know whether it did so for that purpose, because in subparagraph 8, the judge is saying there is no evidence that consideration was given to the interest of STIC.
Yes.
I mean, I can see the argument, obviously,
Yes. No.
but it's not for me to impute a purpose to a commercial company.
No. No, and I mean, I think the answer is there was I mean, we didn't have Mr. Lowe there as being the person who passed the resolution. All we can do is we can piece together what is the likely thing to have happened in circumstances where, as a matter of practice, STIC is a very significant gainer as a result of doing this. And
who drafted the resolution for Mr. Lowe to pass? And is there any document at all of any conversation between anybody and Mr. Lowe? Even a diary note to say that somebody rang him on a certain day?
My Lord, I don't know who drafted it. Okay, in cross-examination by my learned friend, WKC accepted that WKY and WKC instructed Mr. Lowe to issue a conversion notice. That you get from 7805, line 24, to 7806, line 7.
Thank you very much indeed.
Sorry, my Lord.
Thank you.
But nobody asked Mr. Lowe to produce his file.
I mean, I imagine as part of the disclosure process, his file would have been produced. I can only take it from the fact that there is not any such documentation, that there's no documentation of that nature on Mr. Lowe's file.
It might be said that's surprising from a professional person, that he hasn't documented why he's doing this when he's got a fiduciary responsibility. It might be said, I don't know.
Yeah. Well,
thank you. We'll have to consider these points. Thank you.
well, would you give me just 1 minute?
Page 7805 ends with the proposition that he has absolutely no idea as to whether Mr. Lowe understood what he was signing.
Well, the only thing I can say in relation to that is that WKC at that moment was obviously in Malaysia. Mr. Lowe, I believe, is in Hong Kong. One might add that, of course, at this moment in time, the person who was in charge, if you like, of the whole group was WKY. And I'm sure you've picked up, we did put forward witness statements from WKY, and we applied, because on health grounds, for him to be able to give evidence by video link. That was opposed. In the event, WKY said, I'm going to follow my doctor's instructions and not come to the BVI. So, obviously, he did not end up being cross-examined.
Did his statement go in for what it was worth?
His statement went in parts. It's in the bundles, partly because WKC cross-refers to a chunk of it at the beginning.
So it doesn't go in as evidence, but just as a convenient summary of something which KC said in the witness box. Is that right? Or said in his own witness statement?
No, my Lord. You had two witness statements, one from WK, well, actually more than that, but WKY made a witness statement. He was, of course, the person who was actually really running the group. WKC made a witness statement. He lived in Australia.
Yes.
right? He, as part and parcel of doing his witness statement, he did what I hate to see, which is he said, I agree with everything in paragraphs X to Y.
Well, that's why I asked you to put the question out. As I understand it, the judge didn't let KY's evidence go in uncross-examined, but what he did do was to allow one to understand KC's evidence when KC incorporated by reference something KY had said.
That's exactly right.
Yeah. So it didn't. So KY's evidence didn't go in as evidence.
KY's evidence did not go in as evidence, I don't believe, save for those parts of it that are incorporated by WKC.
Yes.
But as I say, I mean, he was prepared to be cross-examined by video link, and we might have rather more information if that had happened. I mean, I'm going to come on to references to Rayleigh and all that at some stage, because it seems to me that they are not really relevant. But as a matter of practice, of course, by the time we got to Rayleigh, everybody was giving evidence by video link because of COVID. And of course, when that happened, he came to be cross-examined for whatever it was, a couple of days. So at the time when the refusal was made, we were sort of in the sort of former dark ages where everybody took the view that, no, you can't give evidence by video link.
But I mean, that refusal wasn't appealed.
Sorry?
The refusal to permit him to do that wasn't appealed, as I
No, but the application to permit him to do that was made, I think, a matter of 10 days, 2 weeks before the trial was due to start. I mean, I think I was there. It might have been on a sort of pre-trial review or something like that, but it was pretty shortly before the trial was due to start.
We've probably rather forgotten how clunky that video link process was before the pandemic.
It's got a bit better.
Particularly if it relied on the parties giving the evidence and the parties cross-examining having paper documents, which tended never quite to marry up.
Yeah, I mean, I've certainly seen lots of paper documents being used in the context of that. But I mean, of course, it is better now.
Yes.
Because they've obviously had to improve it than it was before.
Can I just summarise where I think one's getting to with this improper purpose issue? As I understand it, we've here got concurrent findings of fact. So Mr. Crowe is going to have to show to us that there's been something exceptional, which we might just class for these purposes as an error of law. The argument against you is there was an error of law because no separate consideration was given to the interests of STIC. The answer that I think you're giving is that although that's the case, an inference was drawn that it was for a proper purpose because objectively assessed, that is, looking at all the evidence, it was for the benefit of STIC. And is that, as I understand, where we've got to?
I think that's where we've got to. And it was for the benefit of STIC in two ways. It was for its benefit because it received something worth an incredible value by reference to the 27,500 ringgit that was being paid on an annual basis. So 5,500 compared to something like 36 million. And it was also for its benefit because it is a shareholder of WTK Realty, and as a shareholder, it would obviously not want one of its subsidiaries to default on the loans from HSBC and or SCB.
Did it make inquiries into what the financial position of Realty was and whether it needed this further fund and whether it approved of the expansion of business involved?
Well, So, sorry, did I make inquiries of?
Realty. Did the directors?
Well, the directors were Realty.
No, sorry.
Oh, sorry, I'm sorry, my lady. Sorry?
Directors of STIC, they're the directors we're concerned with at this point.
Yes. I mean, my lady, I can't answer that question because there's no evidence one way or the other. I mean, obviously, as I say, WKC was there to be cross-examined. That sort of a question could have been asked. And obviously, it's ultimately not my fault that it wasn't. I don't mean that in any way disparagingly of the team on the other side.
But there's no evidence of financial information flowing from Realty to the board of STIC, which is then duly considered.
I don't believe, in the sense of what my lady's talking about, is a hot piece of paper showing that took place. I don't believe that exists in the bundles we've got.
Well, I think it goes further than that. The page, which I've very briefly looked at, of the cross-examination doesn't show any oral communication either. No written evidence and no oral evidence of financial information being provided to STIC.
Because the question wasn't asked, or?
Well, nobody led any evidence about it.
Well, perhaps it's just that the whole case wasn't actually put in this sort of way at the relevant time. I mean, it was very much put on the basis of. I mean, I think I go back to it, is that ultimately what the judge had to decide was, did he believe that this was done for the purposes of meeting the revised requirement in order to get money out of AmBank, so that when the SCB and HSBC loans had to be repaid, there was money to repay it? Or did he believe that in fact what was being happened here was an illegal attempt to increase their shareholding? And that's really what the two issues were.
So that the issues were, what were the purposes in the brothers' mind? Was it the one purpose or the other purpose? And nobody really addressed the transfer of that purpose, if I can put it like that, to Mr. Lowe.
I do not remember that happening.
Or whether it was improper, not because of the purpose, but because it was or wasn't for the benefit of STIC. That's not. I
do not remember that happening, but I'm sure. I mean, we were all there for the trial. I'm sure if it did happen, then my learned friend will be able to show you give you an indication of where that particular point was actually raised and dealt with. Yeah. The next thing I was going to go to was section 175. I'm obviously running out of time, I can see it. I think I better try and do these next sections quite quickly.
Yes.
Given that I've got about 30 minutes.
The time is not being wasted, Mr. Alexander.
Section 175, which is paragraph 35.25 of the SFI, which is page 9268. It said that the conversion was a breach of section 175 on 3 bases. STIC surrendered its only assets, which was immediately cancelled, and in exchange STIC received different property. Secondly, this was not something which was done in the usual regular course of business. And thirdly, that the disclosure and voting requirements can't be satisfied by an informal majority approval. We've dealt with this at paragraphs 106 to 129, which is page 9367 to 9272. Obviously, it's a slightly unusual provision for English lawyers because I don't think there is a provision like this. Unlike many Companies Act provisions which find their way into BVI legislation, this is one that just doesn't seem to come from England, which was why we thought, well, if it doesn't come from England, where does it come from? And I mean, ultimately, you may or may not find it of interest or useful to see what we obtained. I wasn't going to go through all of that in any detail. I think in the light of what my learned friend said yesterday, I'm going to leave it to you as to whether or not you find it of any use. And I'm going to turn... It's all
set out at great length in your written case anyway.
Sorry, Mark?
It's all set out.
It is all set out in our written case. So, against the background, against the sort of the background that I've just referred to, we've dealt with whether the conversion is in fact, I think we start the point with this was a conversion. I'm sure you've got this point. It is a conversion, and everybody's called it a conversion, and therefore it doesn't fall within the wording of the Act. Secondly...
Is a conversion of one kind of shares to another always by way of cancellation or redemption and reissue, or does it depend on the constitution of the company or the terms of the shares?
I think there are probably, I mean, I'd almost like to ask Lady Arden this question myself, rather than trying to answer that. I mean, I'm kind of going to say I suspect there's more than one way you can do this sort of thing.
Well, it may be significant as to whether it's just by happenstance then that some conversions will fall within 175 and some not. Some might fall within 175 on the appellant's case and some not.
Well, it's a very strange thing, this, because this is a CPS which has a built-in right that everybody agreed to back in whatever it was, 2004, 2006, and at that stage there were only three beneficial shareholders and one legal shareholder. Undoubtedly, the 3 beneficial shareholders said, "Okay, this is a jolly good idea, and now from now on, you can exercise the right to convert whenever you so choose." But then suddenly it gets caught by a provision later on, which I mean I think I would suggest is designed to stop someone walking off with, the entirety of the company's assets. It's really that.
To stop directors disposing the assets on their perception of whether it's a good idea or not, without the shareholders being consulted and a majority of them agreeing, isn't it?
Yes, and that makes it very odd in this case, where you have a situation where you've already got an existing right to do that has in fact been approved by all the beneficial owners in this particular instance, and with it having been effectively built in, we would just say it just doesn't fall within the ambit of what was intended to be caught by this section. I can't make the point again and again. I mean, it is there, and you either like it or you don't like it. The judge liked it and the Court of Appeal liked it, but that doesn't really help me, does it? So, it depends on how it appeals to you. I mean, we obviously say we think that's the right way, and in due case we'll find out whether we're right or whether we're wrong about that. As regards whether the conversion was in the usual or regular course of STIC's business, I mean, the judge didn't make a determination, the Court of Appeal did. They said that the conversion was not made outside the usual or regular course. We're obviously aware of the CYBAN matter, both at first instance and in the Court of Appeal, and indeed of my Lord Boroughs' observations in CYBAN in the Privy Council. Notwithstanding that view, we are going to submit that in the present case, the conversion was in the usual or regular course of STIC's business. I mean, from the time when the CPS were issued down to the time when STIC elected to convert them into ordinary shares, we say STIC had one primary function: to hold the CPS until STIC determined when to convert them, and then once converted to hold the ordinary shares in Realty. And that, we would say, is STIC's business. It was STIC's only business, and therefore it would fall within the category of being STIC's usual business, in the sense that that is what is anticipated, that the business that STIC would in fact engage in. Obviously, if the American materials that strike you as remotely attractive, you also have the point that comes from them, is that the usual and regular in the context of a similar provision, I accept it's not the same provision, they seem to interpret that as in a rather different way, as one might interpret usual or regular course of STIC's business if one was just reading it as a matter of the words. In the sense that the transaction in question didn't strike at the heart of STIC's existence or purpose. It had no negative qualitative effect on STIC. Indeed, as I've already said, it had a very positive effect on STIC. So it ended up with 2.75 million shares, worth much more than what it got by way of dividend. We then mention, and this will be very familiar to all of you, that we mentioned the point about, look, WKC and WKY were the beneficial owners, and on that basis they approved it. We say that actually there's nothing to stop them doing that now, and that if they were to do it, that it would get approved. We refer to the line of authority about informal approval, which I won't take you to given the time, and also because I suspect you're very familiar with those cases. And we say that, look, if formal notice had been given, nothing would have changed on the facts of the present case. Finally, we can, well, not quite finally, but we can also say that, look, the appellant knew all about this. She received a notice of the convening meeting of the EGM, and she actually wrote asking to say, could that be postponed?
You mean the EGM of Realty?
Of Realty, yes. That then brings me to the next point, which is that, you know, even if the judge and the Court of Appeal were wrong to say the conversion was not a breach, at the end of the day, the question is this unfairly prejudicial to the appellant? And we say it's not. It affected all the shareholders equally, and it meant that STIC held 14.4% of the shares rather than the CPS, which gave it a more direct right to the assets of Realty. I think yesterday my Lord Briggs put this as this is a bit of a technical breach, and I think my learned friend Mr. Crowe.
I didn't. It was Mr. Crowe.
It was Mr. Crowe. All right, it was Mr. Crowe. Well, Mr. Crowe, I think, you know, identified that this is a bit of a technical breach.
Just to be clear, I hope the transcript will show that I asked whether Mr. whether this was a technical breach, and Mr. Crowe, I think, said he thought it was.
Yes,
I mean,
my lord, I think
he
that's
didn't say
probably
it was a meaningless breach. He just said it was technical.
yes, yes. I think that's probably fair.
He then slightly went back on
Yes,
that.
he did.
I think.
It is.
When he accused me of it and had it back down his throat.
Is there a case that you can point us to that, I mean, the case put against you is, well, technical or not, it was unlawful conduct, and that of itself is unfairly prejudicial. But is there anything you can point us to where a court has said, well, never mind, if things are just technical breaches that they don't... No. Presumably you would have found something if there was.
I don't think I can put it that way. All I can say is that there was an informal approval. Okay, so there is a technical breach, but no harm comes of this. The case
no harm comes from it over and above the harm of the conversions, I think.
If the conversion is a harm.
Yes, but this is put forward as a separate point. So I think you're saying that there's no additional prejudice, even if the conversion is a prejudice. There's no additional no additional prejudice arising from the allegedly illegal way in which it was done.
Yes, and I think the case you're referring to is that the Somal Lee case that my learned friend referred to yesterday.
I'm asking you, I'm not referring to.
Which was Mr. Justice Wallbank from yesterday. I mean, look, I can't find a case which helps me in that way. What I can say is that the case that was referred to, the decision of Mr. Justice Wallbank, please look at it. It just seemed to be a million miles away from our case. I mean, it is the two disposals were a dilution of the members' shareholdings from 62% to 28%, and then a wrongful disposal of the company's remaining shares. I mean, this particular case is an asset stripping case for an illegitimate means, and essentially it saw someone walk off with the assets of the company. That is not the case in our case. Our case is a completely different one where you've actually got a right to actually convert these, or contractual right to convert these at any stage. And, effectively, the constitutional documents actually anticipate that this is what can actually happen. I also add in relation to that case, it's pretty recent. I wouldn't be at all surprised if that one is vulnerable to an appeal. Who knows, maybe it'll come to you in due course. Can I just go very quickly to section 59?
Just before you do, you did say that there was no equivalent in the UK Companies Act to section 175, but did you look at section 189?
Off the top of my head, I mean, I have scrolled through the whole thing, but I can't honestly stand here and say I looked at 189. I may well have done.
Yes, introduced 1980, just before this legislation.
Right. Section 59, which I think I'm going to have to take very quickly, but I think we've got quite a lot of this in our written thing. There are 3 points to this. Was the 550 actually paid? Was the 2 million paid? And can the 550 be credited to the subscription payment made or due on the shares in April 2013? I mean, as a matter of fact, we say both the 550 and the 2.2 million were obviously paid. As regards the 550, we've set that out in paragraph 138 at 9375. And there are quite a lot of things there that are documentation, which it would be extraordinary if any of this documentation came into existence and the 550 hadn't been paid. But there is actually one killer point to this one. I mean, there aren't many killer points in this case. that one's able to refer to, but there is a killer point, and that's this. The appellant has previously personally accepted twice in proceedings in Malaysia that Realty received $550,000 for the CPS in 2004. And you can see that at 7649 at lines 1 to 21.
2649?
7649.
So sorry.
And the lines, sorry?
Lines 1 to 21.
Thank you very much.
I fear that's 1 to 21 is probably pretty much the whole page, but at least it tells you where to start, where to stop. Now, the 2.2 million was paid, we say, at paragraph 139. Now, can I just whiz through this and give you some additional references? I mean, there are all sorts of things here that we say plainly demonstrate that the 2.2 million was paid. What I've just got written in mine is that if you look at 139. Okay, the first one is as its references are right. 2, you need to add to little 2, see also 3983. For 3, which is the official receipt, please could you add to your C 3979 to 3980. D, which is little 4, is the data input form. Please could you add 3980 to that entry as well. E is the SCB statement. Please also see 4069. F, which is Realty's audited financial statements. Please add 3248 to 3298.
What, the whole lot?
No, at. Right, this is the whole document. Is that reference? And you need to look at the page that I think helps is 3263. Last one is there's one start the general ledger, which is number 7 in there, and it also says see also 3241 at the entry for 08042013.
Thank you.
Now, that just leaves the third point, which is whether you can credit the position. I think the best way, I mean, we've set out what we want to say in our thing. I think the best thing I should do is my learned friend, Mr. Birdinghouse, referred you to his expert's report. I think I should just give you the relevant passages so that you can look at it from our point of view. It's a very short report. It's a second report by Mr. Srinivasan, which you should find at 2586. And I would only ask that you look at paragraph 4.2 on 2587 and paragraphs 14 to 28 on, that is actually 4 pages, 2588 to 2592. And whilst we've referred to most things, there is actually one other thing which is quite helpful, which doesn't seem to have actually made its way out yet, although it is referred to in our written case. There is an extract from Professor Pennington's Company Law. And what he does is he says there are 5 ways of carrying out this conversion, and he sets them out. And one of those is including by the company consolidating or subdividing the original shares into ordinary shares with a higher or lower nominal value, the paid-up capital in respect to the original shares being allocated proportionately to the new shares. And he says that that would be accepted as a way of doing it if the point were to arise in Malaysia. And that is the very first of Professor Pennington's routes. I think...
Sorry, where are you reading from?
Much further than that. I'm in... I've not taken you to... Perhaps I'll just get you to turn it up so I can show you. It is at 2591. And at 25... it's the paragraph starts, it's paragraph 25. This is the short supplemental report that I was indicating that Mr. Srinivasan did specifically to address this question. And in paragraph 25, he refers to Pennington. And right at the top of 2592, you will see that what Mr. Srinivasan has done is quote from Professor Pennington's book, The 5 Ways in Which Professor Pennington thinks that this could be done. And the first way is the way it was done in this case.
What was done or could have been done?
Oh, sorry, what could have been done?
Yes, there's no suggestion it was done,
It was
as I understand it.
Was done. Well, I think he says it was done.
A subdivision is there of the original press into ordinary shares of a different nominal value.
Yeah, I mean, I certainly take it from paragraph 26. I mean, there wouldn't be much point in having 26 if he didn't think that was what, in fact, had...
I thought he was addressing the point that you couldn't do this without a court-authorised reduction of capital.
No, that's the other expert.
Oh, I'm sorry. Okay.
My lord, this basically, that's why my learned friend showed you the passages from the other expert.
Yes, but I thought he was addressing that point.
No, who my expert?
Yes.
No, he's addressing, these are the 5 ways in which you can do it. And from memory, I believe that item 1 was the way in which it was done in this case.
So there's a resolution somewhere, is there, for consolidation and subdivision?
Good question, my lady.
I don't think so.
Well, isn't the point that it's only if you can't allocate the 550,000 to the consideration to beef it up from the 2.2 to the 2.75 that you're in the territory of the shares being issued at a discount contrary to section 59 at all? That if you can move the consideration across, then they were paid for at par, and so there's no issue of the shares at a discount. So one has to deal with the first question of whether it's legitimate to use the payment for the original shares as part of the consideration for the payment of the converted shares, or the proceeds of the conversion.
As you were saying that, my learned gentleman was saying yes, 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 you could probably hear.
Well, I take comfort from that.
They were nodding as well as muttering, Mr. Alexander, so it was very helpful.
We say there's no breach of section 59. And of course, at the end of the day, we say, look, you know, even if there was a breach of section 59, you've actually got to look at it in this way. I mean, section 59 causes a problem for individuals at WTK Realty. It doesn't cause a problem for individuals at STIC. And the penalty for those individuals, if they fail to do this, is 1,000 ringgit. That's about £180, I believe. So,
Yes.
obviously, whilst one has to do it, there are obviously many more things which are much more serious than that. Well, I think what I'm going to have to do is I'm going to have to stand on what I have said in my written case in relation to what is set out under the headings. I'll just give you the headings: loss of trust and confidence, dividends and information, witnesses, because there are a couple of things I want to do in relation to just and equitable winding up. I obviously did already with you that there are obviously disadvantages, and the way we put this in relation to this is obviously you have to engage section 184I1. You have to demonstrate unfair prejudice before you can get to 184I2. Even if we get to unfair prejudice, we say unfair winding up would be inappropriate. At paragraphs 172 and 173, which is at 9383 to 9384, we set out the material provisions in relation to winding up in the BVI. They include the 1673, which provides that the court shall appoint a liquidator in certain circumstances, unless it's of the opinion that some other remedy is available, and the applicant is acting unreasonably in seeking to have a liquidator appointed in pursuing that remedy. We say, obviously, there is an alternative remedy. It's the buyout, which is what the judge thought was the right thing to do, and the Court of Appeal seemed to have gone along with that, despite the perhaps odd difficulty in how one got there in the first place. I mean, obviously, buyout order, we would also say, I mean, that's the normal order that the court would make in relation to a company on a just and equitable winding up. We would also say that we'd also add to this that there's no reason why, in relation to a solvent company, the wishes of a minority shareholder should prevail over the wishes of the majority, particularly when the company in question can clearly function properly outside liquidation. That takes me to all I wanted to say about 3 minutes, I think. Can you write it out for me? Yeah. The last thing I think I wanted to do was just to just touch on the question of Rayleigh, which is the other case which is currently going on between the parties here. I mean, it's obviously another set of proceedings in the BVI where the appellant is in a representative capacity, the claimant, and we are 2 of the 5 defendants. There was obviously no reference to Rayleigh in anyone's written case, well, no real reference. It's included as one of the appellant's authorities, but we would say it doesn't support any legal proposition at issue in these proceedings.
What's the page number for the authority?
The page number for the authority is...
Oh, gosh. I mean, not to worry.
No, I'll get it,
Please don't take your time.
Okay. I mean, I will get it for you, obviously. I mean, it seems to us that this has been included. I mean, basically to say that...
Is this the case at 12395?
Is really...
I see. You call it Rayleigh.
I call it...
Mr. Crow called it Incredible Power.
They are the same case.
Why there was some confusion.
They are exactly the same case. Incredible Power is, I think, from memory, the first defendant.
Yeah.
Rayleigh is, I think, the fourth defendant and is the company about which everything is about. And the claimant is the representative of Rayleigh in that case. Now, we can't actually see that it's there for any legal proposition. It relates to completely different to the facts. The facts in STIC are completely different. It also has completely different issues. Our understanding of the position is that on account of, I think, the rule in Hollingworth and Hewthorne, findings of fact in other cases are inadmissible in other civil proceedings, and that's carried through even more in BVI by Section 90 of the BVI Evidence Act, which says, with certain exceptions, it's not admissible to prove the existence of a fact that was in issue in those proceedings. If they'd really wanted to adduce further evidence, then it seems to us they should have made an application to bring that case in as a fact in this case, and we obviously would have opposed that. But I'd only add this. The present case and Rayleigh are both, as I'm sure you've picked up only too well, part of a family dispute, and findings are and have been made by different judges in different courts around the world. Some cast my clients in a favourable light, some prefer the appellant. But attempts to bring in judgments for other cases, anything other than for a proper legal principle, so as to try to change the narrative of a completely unrelated appeal, we say should not be allowed. And I should only add to that, that is especially the case when Rayleigh is going to be appealed. And who knows whether it ends up here. That is all I want to say, other than one thing, which is I noticed right from the first observation you made in relation to this case about for counsel. And I think it might have been about him rather than me.
Yes.
But I am actually only me and Mr. Perkins. You can cross the other two who are on the list off. They're not here.
Oh, well, thank you. I was actually talking about counsel for the third respondent.
Yes, I thought you probably were, but I'm in exactly the same position. So I thought I'd better take some of mine off. And I suspect he's going to tell you some of them are not here as well.
You've been doing all the talking, Mr. Alexander, and we are always grateful to those behind counsel who's doing the talking for all the, no doubt, enormous hard work they've done to make the talking even more effective.
Absolutely right, my lord. Wholly endorse that.
Mr. Alexander, could I just gently remind you about the resolution that was drafted, potentially drafted, for Mr. Lowe to sign? I'd be interested in finding out who drafted that, because, for instance, if it was Reality's solicitors, it might be of interest.
I will.
And how it got to Mr. Lowe.
I mean, I may not be able to get that for you today,
Don't worry.
but if you are happy to have a short letter attaching, which of course we will copy to everybody else, we'll deal with it that way. And I think you wanted did you want the reference to Incredible Power / Rayleigh, or?
I think once I got the right name. Okay.
No, well, I'm sorry, my lord, we have different names for it. So.
Yes, indeed.
Thank you. Unless there's anything else you want to ask me.
No, thank you very much, Mr. Alexander.
I stand up with hesitation, but I am the third respondent. Mr. Goodison for STIC.
Yes.
Very briefly. Lord, I hesitate to stand up, but the respondent's speaking time has expired.
Yes. You're going to have to be extremely brief.
I'm going to be, and it's only from points that have arisen. I have three very short points. The company's obviously neutral. The section 184I, so this is the E-bundle 9504. You'll notice from 184I sub 3 that no order can be made against the company unless the company is a party. So it's slightly different to the practice in this.
That.
Yep.
Company must be a party. That comes as no surprise.
Exactly. And the shopping list in 184I sub 2 is wider than our law, because it expressly includes not only buyouts as the first, but an appointment of a liquidator. And also here, you've got the just and equitable process that you use. That's the first point. The second point just arises as regards, is liquidation a good idea? Can I take you to the E-bundle at 2651, so you have, because your 2651 is the articles, and this is a point about, so 2651 at Articles 104, because the articles were just referred to earlier. And liquidation, this is the point that liquidation will cause more litigation. Obviously, I'm neutral, but we have our duties as the company. To, now, under 104, there's a clause in the article, slightly unusually, that winding up, the members can pass a resolution to divide among the members in specie. The liquidator has a discretion, but the members can pass a resolution for distribution. That would be the shares of realty in specie. So it picks up Lady Rose's point. So the point here is that if you have firstly, there'll be litigation possibly about that. Secondly, there's actually an arbitration clause in the next clause, 105. Point being, litigation is going to continue if a winding up order is made. This assumes Mr. Crow's right about all his points. And if you get a distribution in specie, then of course you end up probably long-term back where you are at the moment with a buyout, because you end up with the realty shares being distributed in specie to the 3 present shareholders.
Well, I've got
that. I'm grateful. The third point I have very quickly is Lady Arden made the point, this is in fairness to Mr. Lowe, because the STIC points about the purpose. Mr. Alexander made all the points about the commercial purpose, but the evidence that hasn't been referred to, that in fairness to Mr. Lowe I ought to refer to, is at page 247. Mr. Lowe didn't give evidence, but at 247 of the e-bundle is paragraph 29, which is the pleading, and at paragraph 29b, it repeats what Mr. Alexander has said already, which is the commercial purpose of the resolution. And Mr. Lowe signed a statement of truth at page 250. So that there is evidence, but this obviously wasn't investigated before the judge. Those are the 3 points. And my last point, just as a courtesy to the court, is we are not full counsel. It's just me as junior counsel with a very junior solicitor. And so the list is.
Nothing's gone horribly wrong with the list.
Yeah.
Yes. Well, I take back all the horrible things
I'm very grateful.
My solicitors occasions.
My solicitors have been very nervous.
In those circumstances, the list is right.
So there's my submissions, unless you...
And they are, of course, equally welcome, I hasten to
add. We're very grateful.
Yes, Mr. Crowe.
Could I just start with some brief observations about the overnight authorities? I think these were prompted by a question from my Lady Rose as to whether there was any case law indicating that equitable considerations could extend to the surviving spouse. We came up with a case that has been sent to you overnight, Galeli, which illustrates exactly that. Milano Friend has come up with 5 authorities. His sort of lead case is Ting, which is in the bundle that he has made available. Could we just offer these thoughts in relation to Ting, which I think can then be read across to the others? If you simply look at the head notes in Ting, you will see, I don't ask you to get it out now, but you will see that the decision was in a case involving 2 business partners, each with a wife. It was a quasi-partnership in the arm's length, so to speak, business joint venture sense. It was not a family company. There were also transfer preemption provisions in the articles, which one sees from paragraphs 9 and 98. So where in that case the court was saying anything about the transmission of entitlements under a quasi-partnership to a surviving spouse, it was saying so in the context of a business that was not a family company. And for that reason, in our submission, you get nothing of assistance in answering my Lady Rose's question by looking at that case. Similarly, you may wish to look at the facts of the other cases. Really, all you get from them is that different factual situations have produced different answers. There is no authority to suggest that in a family company, equitable considerations do not extend to the extended family. And to try adopting what my learned friend did, which was the language used in Ting about the transmission of entitlements under quasi-partnerships not being available to surviving spouses, is, with the greatest respect, simply a misapplication of the fundamental principles from Westbourne Galleries onwards, because it treats equitable considerations as if it's some sort of enforceable legal right that can be transmitted.
You just mentioned Westbourne Galleries. I wondered if you were going to mention that Lord Wilberforce and the House of Lords had disapproved what Mr. Justice Simmons had said in Cuthbert Cooper.
Exactly so. That is one of the passages. I know I didn't ask you to open Westbourne Galleries, but that is absolutely one of the passages which, when I was opening, I invited specific attention to. And yes, we certainly do rely on that. But
it doesn't absolve the court from working out what the relevant equitable considerations are, does it?
Absolutely. No, I entirely accept that.
Quasi-partnership, one sort of knows what those equitable considerations are. They're what arise from the law of partnership.
Yeah.
I mean, I put that to Mr. Alexander. I'll put it to you, even-handed with it.
No, absolutely so. And the challenge in any case is to look at the indisputable facts and make a legal determination of whether equitable considerations do apply. Now, I'm not going to go back over the indisputable facts in this case, but you will recall that what we have here is a third generation of a dynastic family business in which, as you turn the company accounts year after year, you see shareholdings and directorships being spread out and down through successors. And we say that, as I opened yesterday, the question whether or not equitable considerations apply is a matter of legal appreciation. It's not a question of finding fact, and it is a matter of legal appreciation to which there is, with respect, a right and a wrong answer. It's not a matter of a discretion. It's not, as my learned friend said at one point in his submissions, how sympathetic the judge is feeling towards the claimant. It is a matter of legal appreciation as to whether or not equitable considerations apply, and therefore a bit like, if one can draw an analogy, if it is useful here, a bit like issues that arise where an argument is being had about whether or not a certain set of proceedings constitute an abusive process, where the court is called upon to consider whether or not proceedings are an abusive process. The court says, yes, the first instance judge makes a judgment, and assuming the judgment is based on a proper understanding of the facts and the law, it is a judgment which is entitled to respect. But nevertheless, the question of whether there is an abusive process is a question of law. And similarly here, we say the question whether or not equitable considerations extend to the circumstances of this case is a matter of legal appreciation based on the facts. If the first instance judgment had conducted that exercise, his decision would have been entitled to some respect, but he just didn't do it. And the Court of Appeal, for the reasons I addressed to you yesterday, didn't do it at all in relation to Section 184I. And when they turned to the freestanding, just and equitable winding up relief, they simply did not address the wealth of evidence. And I would simply urge on you, I'm not going to go back to it now, but in our closing submissions at trial, we listed at paragraph 41, or is it, hang on, is it in the Court of Appeal? Sorry, I think actually it might be...
Is this the yellow document?
Yeah.
I wonder if, since you mentioned it, is it possible to have just a copy of the yellow document the right way round?
Right.
We've got hard copies, but they were spurned by the registry, so we've got one printed. hard copy, if that would be of any assistance. We can have them sanitized, if that would assist. But
I'd like to have a copy. I don't mind.
We don't mind it being yellow, but it needs otherwise to be clean.
They are there. So if you look at paragraph 41 of that closing, you will see the wealth of evidential material, which is simply not addressed in the courts below. And that was partly directed to my Lord Burrows, because your Lordship yesterday said to my learned friend, so what you're saying is that the court below has reached a view on the question of whether or not equitable considerations apply, which a reasonable judge could have reached. And our answer to that is threefold, essentially. One is, it's not a question of reaching a finding of fact on which different views could be taken. It is a question of law on which there is a right and a wrong answer. Our second point is that the judge below, the trial judge, made no finding on it that warrants the description judgment, because he just doesn't address the evidence at all. And our third point is that the Court of Appeal does engage with it, but so on such a whole-scale basis ignores the evidence that its judgment should not be accorded respect. And you, being another appellate court, are in every bit as good a position as the Court of Appeal was to form your own view on that question of law. The only other point on that issue about equitable considerations extending to surviving spouses, which I just would remind you of, and we may have made this point perfectly clear, but to repeat the obvious, my client is the surviving spouse, but she is suing as executrix of the estate on behalf of the successors, which are her and her late husband's son and daughter. If you want, I don't suggest you get anything much from it, but as it happens, the will is in the bundle at page 4240.
I thought that they were involved in the running of the group in some way.
Neil and Mimi, yeah, exactly so. Exactly so.
It has worked in that.
Absolutely. Yeah, exactly. So they are part of what I have been calling the WKN side of the family. So she is suing on behalf of that side of the family. It's not just in her capacity as a surviving spouse. She is suing on behalf as executrix of this. Yeah.
As yet, I assume, unadministered estate.
Yeah, exactly. Just a couple of other very short points on the law. My learned friend, in relation to Chow Kwok Chuen, said that case was a case founded on deadlock. With the greatest respect, if you read that judgment from paragraph 20 onwards, which is page 11218, it is perfectly clear that the court is not using deadlock in the sense of a 50-50 shareholding company in which decisions cannot be taken.
I.e. not functional deadlock.
Exactly. It's talking about the kind of awful personal breakdown of relationships where nobody's getting on, which would justify just an equitable winding up by reference to Westbourne Gallery principles. Paragraph 20 onwards, it makes that in our submission entirely clear. Another question from my Lady Rose asked if there is any evidence of family members being paid despite not being involved in management. As it happens, part of the cross-examination of WKC, to which I invited your attention, contains, again, some slightly bleakly comical exchanges. If you look at page 7738 onwards, I'm cross-examining case. I don't suggest we go to it now, so it's about 6 or 7 pages, although you can read it quite quickly. But 7738 onwards, I cross-examine KC on some company accounts. Despite having been a director of WTK Realty from 1981 onwards, he claims never to have seen the company's accounts. When cross-examined on the fact that there is a plummet in directors' remuneration, which we say is because the minute KY and KC took control, they stopped paying Mimi and Neil. He claimed not to have seen the accounts and couldn't answer that. When asked what he did as a director of Imbok, which was one of the companies that paid salaries, he said nothing much. So I asked, well, do you get paid for doing nothing much? And he said, well, I turn up at some board meetings. So there is a rich theme both of depressing evidence in our submission, indicating a willfulness simply to appear to know nothing when it suited him. And as it happens, also evidence of being paid for doing nothing much in his own words. My learned friend said yesterday that there is no evidence of STIC being run in an informal way. Could I also tie this to an answer to a question from my Lord Briggs, apropos a question today, did WTK Realty owe STIC money? It will be recorded in the accounts, Your Lordship assumed. Could I very briefly ask you to look at page 7721, which is no, I don't mean that, sorry. I do apologise. 9721. I can't read my own writing. No, it's not. No, it's not that even. Sorry. Hang on. 7223. 7221. 7221. Let's go with that. Yeah, it is. Sorry. 7221 is a table from the other side. Solicitors in response to requests for specific disclosure. And you'll see item 1 is our request, left-hand box, STIC's financial statements covering the whole period of its existence. Middle column explains why we want to see them. Right-hand column is the answer. This is a repetitive and unnecessary request as our client's position has already been set out. As far as our clients are aware, no such documents exist. No financial records at all. And if you go on...
This Ting must have got her information somewhere, presumably Realty's accounts.
What can I say? Page 7223, request 10, bank statements. Right-hand column, our clients were not and are not aware of any bank accounts held or formerly held by STIC. How could it possibly have owed money to WTK Realty or incurred any kind of intercompany debts if it didn't have a bank account?
Easily. Well, it could have...
All right.
Easily.
Paragraph 11. Statements for all trading accounts held or formerly held. Answer. No relevant documents.
Well, it wasn't trading, so it's unlikely to have any trading.
Right.
That is the evidence as to the existence of any financial records for the company. No bank account, no accounts, and no financial records. Okay. So the answer to the question is there evidence of STIC being managed, run in an informal way? Yes, if it's not keeping a record of anything that has happened. Given the shortage of time, can I just turn to one substantial point that has emerged today, which is the purpose for which the conversion was effected. The judge, as you will have seen, because I think my Lady Arden drew attention to this, paragraph 1718 in the first instance judgment, observed there was no evidence of the purpose for which STIC took the decision. That's page 87. In our submission, the Court of Appeal, in dealing with this, has made an error of law, which is significant, and is apparent in paragraph 107 onwards of the Court of Appeal's judgment, which you'll find at page 146 in the bundle. So it's paragraphs 107 through to 110. And what the Court of Appeal does, in order to sort of paper over this particular crack, in 107 to 110 is to say, well, look, if you have a situation where directors of a company do not apply their mind to the question of whether or not a particular transaction is in the interests of the company, the court takes an objective view as to whether the court, thinks a reasonable director would have thought that the transaction was in the interests of the company. And it resorts to Chartbridge, and it refers to specifically Antov Holdings, which is an application of cognate principles in relation to the BVI. With respect, that does display a misreading of Antov and an error of law. Antov is in the supplemental authorities bundle at tab 1, page 3. I don't ask you to get it out, but can I just walk through what we say is the right analysis? If you go in Antov to paragraph 22 onwards, the judgment is there dealing with the director's duty to exercise their powers in good faith in what they subjectively believe to be the interests of the company. It is in that context that the court says if the directors have not applied their minds to the question of an intergroup transaction and they haven't applied their minds to one of the group company's interests, which they should have done, in that situation, the court applies the Chartbridge test and considers objectively whether the court thinks that the transaction was in the interests of the company. That is not our case. Our case is improper purpose, and that is dealt with separately in Antov, in the same judgment, if you look at it from paragraph 47 onwards.
Put a bundle reference page.
I'm sorry, yeah, so it's in the supplemental bundle. The judgment starts at page 3. Dealing with the subjective good faith obligation is at page 12 of the bundle, and the relevant section dealing with proper purpose is at, it starts at bundle page 19. I'm conscious of the time, but I did start a little late. Could I just have another few minutes? Is that all right? And what the court does there is, in our submission, entirely correctly, not to adopt an objective approach. In fact, if you go to paragraph 71 of the judgment, which is page 27 of this bundle, at the very bottom of page 27, what the court there says is, in my view, the test to be applied at present in the substantial purpose test derived from Howard Smith. In extra-short travel insurances, a deputy judge helpfully formulated the proper or substantial purpose test as involving a 4-stage approach. This approach commends itself to me. Furthermore, this approach was adopted in independent asset management, which is another BVI Court of Appeal decision. It therefore requires me to identify one...
Sorry, which paragraph are you in?
Paragraph 71.
Thank you.
Very bottom of page 27, over the top of page 28. It therefore requires me to identify the power whose exercise is in question, 2, the proper purpose for which the power was delegated to the directors, 3, the substantial purpose for which it was, in fact, exercised and decided, and 4, whether that purpose was proper. Now, in a situation such as this, where there is no evidence that any thought was given to the interests of STIC, the director cannot ask the court to assume what a reasonable director would have thought as a substitute, because that simply isn't an application of the proper purpose test. The proper purpose test requires the court to answer the question, has this been exercised for a proper purpose? And if no thought has been given to the interests of STIC, as a matter of law, that test can't be satisfied.
But hold on, you were saying that KY and KC were shadow directors, de facto directors.
Absolutely.
And KC's evidence was that it was done to solve Realty's liquidity problem and not done to shift control.
That was his evidence, and that is the evidence we are asking you to revisit, absolutely.
Yeah.
But the fallback
at this point is designed to sort of finesse having to revisit that evidence.
And we say, as a matter of law, that simply doesn't work. You can't substitute what a reasonable director, what the court...
I'm looking at the actual intention of the de facto director.
Yes.
Which is what you actually pleaded.
Yes, I know that. That's our main case. What I'm...
That the decision was taken by KC and KY, and that it was taken for an improper purpose.
Yes, that is our case.
Yeah.
Absolutely. And that is the case we're urging on you. What I'm pointing out is an error in the Court of Appeal's judgment, because what the Court of Appeal said is there is no evidence that any thought was given to the separate interests of STIC, but that doesn't matter, because the court is entitled to take an objective view of what is in fact in the interests of STIC, and the court takes the view that the conversion was in the interests of STIC. And that, in our submission, is an error of law. That is no answer to a claim based on improper purpose. It is not the court's function to substitute an objective, essentially the court's view of what is in the interests of a company. And so we do say that the true purpose of the decision, the diktat that came from KY and KC was indeed to alter the balance of voting power.
What was
and
the evidence in support of that? How can the court decide objectively that that was when there's no evidence as to what it was? So we have no evidence as to what the purpose was.
Well, there is no evidence that thought was given to the interests of STIC. The complaint is that the decision to convert was taken in breach of the director's duty in relation to STIC.
But if the purpose was to benefit the liquidity of Realty, and that was the subjectively assessed purpose of the de facto directors, then surely the court can take a view whether that's a proper purpose in terms of the interests of the parent, STIC.
I was simply starting from paragraph 1718 of the trial judge's view, where he says there was no evidence in relation to consideration of STIC's interests. If our case, as it is based on improper purpose, what you have to do is to look at what was in fact the purpose of the decision maker. There was no evidence on that. And the absence of evidence cannot be papered over by the court taking its own view as to whether or not the transaction was in the interests of STIC. As it happens in any event, Malone and Friend has said it was in the interests of STIC because I think, in his words, STIC got a more direct right to the assets of WTK Realty as a result of losing its entitlement to the preferential dividend. It does not have a more direct right. What it does then is merely to have a pari passu entitlement to dividends with all the other ordinary shareholders. In our submission, it is a very significant disadvantage to STIC to lose its preferential dividend right. And so, even if it were correct for the court to assess whether a proper purpose has been served by looking objectively as to whether the conversion was in the interests of STIC, in our submission, the right answer is no, it wasn't.
I think we're there, aren't we?
I think we are there. Could I just flick some pages and make sure there's nothing critical that I should also have said?
Just while you're doing that, Mr. Crowe, if you're able to partly concentrate on what I'm saying, you turned the question of equitable considerations in your reply into one of pure law. I think that's the precise word.
It is a legal question, yes.
You started off yesterday telling us there was only one question of pure law, and that was the matter of disposition.
Sorry.
Your categorisation then went on to say that the question of equitable considerations was a matter for legal evaluation from the primary facts.
Yes.
Now, what are you saying?
When I said legal evaluation, having heard your Lordship's question yesterday, I think that prompted me to recognise that when we say legal evaluation, we do mean it is a question of law to which there is a right and a wrong answer. Yes, yes. But your Lordship is right to pick me up on that.
And if I could chip in as well, please, and that is, you say this is a family company, and that equitable considerations then flow from it. In a partnership, in a quasi-partnership, we know what the equitable considerations are. For instance, the duty of the utmost good faith. What is the equitable consideration that flows from a family company?
One cannot give a universal one-fits-all answer to that. In this case, what we say is that the purpose of the family business is to provide a business environment within which growth of capital and income are made available to family members, and the business is operated with such a degree of informality as it is because it is dependent upon a relationship of mutual trust and confidence. And where there is such a fracture between significant branches of the family, it becomes just inequitable for the court to provide a solution. And that effectively loops back into my very starting and finishing point, which is that is what the judge recognised when he granted the order he did. And I'm very grateful. Unless there are other questions, those are our reply submissions.
Well, thank you. And thank all counsel, including their supporting teams, for the assistance with which we have received, both orally and in terms of preparation of written cases. It will come as no surprise that we will take time to consider what advice to give to Her Majesty, and that you have a draft in due course.